was filed yesterday afternoon. The affidavit will appear on item 12 of the bundle in front of you. Unhappily, Chair, there was a problem with printing the annexures to the item, to the affidavit, by our office. But the attorneys of Mr. Wakeford had provided me with the hard copies of the affidavit and the annexures. I have given the chair's secretary that, so that in the meantime, whilst we are waiting for the bundles to be put into the file, we can go on with the printed copy. Your secretary has that. That is where we are. And then, Chair, I've also explained to Mr. Witz that what is going to happen is we'll proceed without the answer from Mr. Agrizi to this affidavit. Then Mr. Agrizi is at liberty to file an answer thereto if he so wishes. Mr. Witz understands that. He was also sent him the affidavit of Mr. Wakeford, the one that was filed yesterday.
Yeah, okay, no, that's fine. That's fine.
And then Mr. Wakeford is here now to testify.
Yes. Please administer the oath. Good morning, Mr. Wakeford. Good morning. Please administer the oath of affirmation.
Please state your names. Please state your full names for the record.
Kevin Peter Edwin Wakeford.
Do you have any objection to taking the prescribed oath?
No objection.
Do you consider the oath binding on your conscience?
I do.
Do you solemnly swear that the evidence you will give will be the truth, the whole truth, and nothing but the truth? If so, please raise your right hand and say, "So help me God."
So help me God.
Thank you. You may be seated. I just want to say this for what it's worth. As the Commission tries to wrap up its work, and with the time constraints that it has, there may be matters where, by the time the Commission wraps up its work, where it feels that it hasn't had the benefit of all the evidence it might have wished to have, or where further investigation may have needed to be done. And in those circumstances, it's possible that the Commission may, in its report, not make any findings in regard to those matters on the basis that more investigations need to be done, or more witnesses, certain witnesses maybe were not heard, in which case it might leave it to law enforcement agencies to see whether they want to take certain matters further. So I'm just mentioning that there is that possibility of that happening because of time constraints, and particularly in matters that fall outside what we have called public protector issues. The matters that we call public protector issues are the issues that the public protector had identified as the matters that should be investigated by this Commission. Now, those matters are matters that are largely related to the Guptas and the former president. But as some of you would know, when the terms of reference of the Commission were formulated by the former president, they went much wider than the issues that the public protector had identified as the issues that should be investigated by this commission. So as a result of that, at the end of 2019, when I applied to the High Court for the extension of this commission's time, I indicated that from then on we would try and focus more on what I call the public protector issues. Because if one were to investigate all the matters that fall under the wide terms of reference, we would take 10 years or so. So I'm just mentioning that it seems that we may have situations where, in regard to some matters, we have run out of time. We haven't, had everybody, or the investigations were not complete. So we might have situations where I consider that it was not appropriate to make any findings, but maybe leave it to the law enforcement agencies if they think they want to take whatever we have done further and investigate further. So I just thought I would mention that for the benefit of everybody. Okay.
Thank you, Chair. Now, Mr. Wakeford, you have made a number of affidavits. When you applied to cross-examine Mr. Agrizi, then Mr. Agrizi answered and you replied. There was an additional affidavit you replied there to, but the latest is the affidavit that you filed yesterday, that was filed on your behalf yesterday. Now, in front of you, there is a file. And in that file, if I can ask you to turn to what is marked as item 12. And you confirm that what appears there is, if you look at the top of that page, where at the top of the left, or the left top of the page, top of the page, BOSASA 04852. You see that?
I confirm, Chair.
Yes, that is where this affidavit begins. And you'll see below that there's a content page, and on the other side, then is your full names. All right. Now, before we go any further, let's do some housekeeping. When I refer to pages, I says BOSASA 04852, I'm referring to the black numbers. And I might not refer you to read the whole issue, I might just refer to the number. So I'm referring to the number. And then, Chair, Mr. Wakeford has got his affidavit, his affidavit that he had printed. He has made some marks on the affidavit. And then I have indicated to him that what we might do so that he doesn't get lost, he can refer us, when he is referring to his affidavit, to what is printed in his affidavit. And then I'll be able to direct it where it sits in the file. Now,
Okay.
Now, Mr. Wakeford, you heard me when I was addressing the chairperson.
Just hang on 1 second, Mr. Knight. I'm just trying to think whether that's not going to be confusing for those who read the transcripts later after the commission has finished its work. Because ideally, when you refer to a particular document, the page number should be the same for everybody. So, but I think you are doing that because you are still waiting for the annexures, is that right?
We're still waiting for the annexures, but secondly, Chair, Mr. Wakeford, in his preparation, he prepared on his own affidavit, the copy at home.
Yeah.
He didn't prepare on this. He has made marks on his own copy, and he has marked it. But what I was suggesting, Chair, is that in the instance...
What I want is whether it's you or him, when you say page so and so, we must all be on the same page. From what you were saying, I got the impression that he might give a page, but on mine it would be a different one on yours.
Yes.
Yeah, that's what I'm on.
Well, what I've guided him to do, Chair, is that I've guided him and told him that he will have the typed page on his document, but in the left-hand corner of on our file, there's a number. That number has got a page. That's what then he might say to you, Chair, can I take you to page 19, but BOSASA 870 for the record.
Yeah, no, I don't want to hear the other page that I don't have. I want to hear only the one I have.
That's fine.
But there's no reason why you can't do that, Mr. Wakeford, because you would know what you have in terms of your own document, but you would know what page. So you just tell us only the page that we also have. Is that
Yes,
right?
yes, Chair. I'll
Yeah,
correct.
it can be done.
That's fine.
Yeah,
Then
yeah.
that's fine.
Okay, all right.
Thank you, Chair.
Okay.
Now, Mr. Wakeford, you heard me when I summarized to the chairperson why you are here and the issues that you are dealing with. Can you, in your own words, just respond to those issues that are before the commission, and then we can then go to details about them.
Actually, that I think that's a good suggestion. It may well be that it might be quicker the way you're suggesting. So, in effect, if I understand you correctly, Mr. Notch, and you must tell me if I misunderstood you, what you would like is that on the topics which you have given, Mr. Wakeford can give his side of the story.
Yes.
And finish, and then you can then question him on the matters. And it's the question of either we take one topic and he gives his side of the story, you question him, he finishes, or whether he gives his side of the story on all the topics and thereafter you question him. Which one?
Chair, I would like is if you give us the whole story.
The whole story.
Yeah, because
no, that's
then-
fine. That's fine.
And then we go into details of
Yes.
of the affidavits.
So basically, Mr. Wakeford, it's an opportunity to tell your story without questions, and questions come later. It might make things to go faster.
Yes.
Yeah. Okay.
Thank you very much, Chair. Chair, I think what I'm going to do is firstly give you my high-level response.
Okay, that's fine.
And then we can get into the meat of it and the
Okay.
substance, if
That's
that's
fine.
okay with you, Chair.
That's fine, yeah.
But I think it's always important for witnesses to speak to their understanding of things.
Yeah.
So my understanding is this, Chair, that there were a bunch of false allegations made against myself and I'm sure many other people. The one allegation, and if I can refer you, Chair, because I'm going to go to part of the document, to page, it says BOSASA 04902. The top left-hand number, is that
Okay,
correct?
I've got that.
So it says allegations and mandate of the commission. So the allegations, and I'm going to read this, Chair, because this is probably the nexus of what I think you need to hear in particular and the broader court of public opinion. The allegations made against me can only be assessed within the scope of the mandate of the Commission in order to establish whether I'm implicated within the mandate as alleged or not. The mandate of the Commission is to investigate allegations of state capture, corruption and fraud in the public sector, including the organs of state. The allegations made against me by Agrizzi and Foster have been fabricated and the facts twisted so as to suggest corruption and fraud in the public sector and to bring me within the mandate of the Commission. However, there is no evidence to support these fabrications. And Chair, I think you'll find within my pack, I'm probably, certainly with regard to the BOSASA work stream, one of the few witnesses who speaks to facts and substance with evidence backing it up. However, there is no evidence to support these fabrications. On a correct assessment of the allegations, the main issues in dispute in respect of the allegations made against me and within the mandate of the Commission are correctly identified as: 1, when Mr. George Papadakis, I'll refer to him as Papadakis in future, resolved a major tax investigation at SARS between the 10th of March 2008, when Papadakis was first employed at SARS, and the 26th of February 2009, when the first order of cement is alleged to have been placed with W.G. Wern for delivery to Meyersdal Eco Estate.
Sorry, Mr. Chair.
Yes.
I beg your pardon for
Yes.
interrupting Mr.
Yes.
Wakeford. I'm following him in the affidavit, but I heard the first word that he read wrong, which changes the context. The first word was whether.
Oh,
So
okay.
it poses
Okay.
the question. Thank you,
Yeah,
Mr. Chair.
okay. You got that, Mr. Wakeford?
Thank you, Chair.
Yes.
Whether I influenced the Department of Home Affairs to extend the initial Lindela contract between BOSASA and the Department of Home Affairs, which I'll refer to as DHA, beyond the 10-year period ending the 31st of October 2015, or extend other financial benefits embodied in the addendums relative to the initial contract. The secondary issues in dispute, Chair, can be summarized as: 1, whether payments of 100,000 per month were paid to me as a fee for providing service in relation to the particular SARS investigation that Papadakis is alleged to have resolved at SARS between the 10th of March 2008 and the 26th of February 2009, or as catch-up payments of my monthly consultancy fee of 50,000 Rand, including VAT, as I say they were. And then the second one, whether cement to the value of 600,000 Rand was provided by BOSASA to Papadakis in exchange for him influencing the alleged major SARS investigation in between the 10th of March 2008 and the 26th of February 2009. And 3, whether payments were made by BOSASA to Radhakrishna in exchange for him awarding BOSASA with a 5-year extension to the initial Lindela contract. And Chair, let me just explain. The initial Lindela contract was in 2005, before my time at Home Affairs as the Minister's project turnaround advisor, and before Anil Radhakrishna had arrived. So it was a good 2 years before that had happened. Based on the evidence in the Commission's possession, the main issues in dispute can immediately be dispensed with on the basis of the following. Sorry, Chair, my mouth is getting dry.
No, that's fine. That's fine.
Based on the evidence in the Commission's possession, the main issues in dispute can be immediately dispensed with. And Chair, I think you will find this interesting. 1, Papadakis could never have assisted BOSASA in resolving any major investigation at SARS before the 26th of February 2009, as it is common cause between all parties that no SARS investigation existed before the 23rd of March 2011. With the first notification of an impending audit being made on the 18th of August 2010. Thus, The first SARS investigation into BOSASA commenced 2 years subsequent to this February 2009 timeframe. 2, no 5-year extension to the 2005 Lindela contract between BOSASA and the DHA was awarded to BOSASA within the second and third addendums to the contract, while me and or Radhakrishna were affiliated with the DHA. No other financial benefits to BOSASA appear within the second and third addendums to the original Lindela contract. So, Chair, the important point is 202.2. No 5-year extension to the 2005 Lindela contract between BOSASA and the DHA was awarded at all. And we have the evidence and the contract addendums to prove that. We also have done some number crunching to prove that, in fact, a lot of money was saved for the fiscus post the turnaround intervention. The secondary issues, Chair, in dispute can immediately be dispensed with on the basis of the following. One, my banking records, BOSASA financial records, and email records between myself and Agritzi all confirm that I was employed as a consultant to BOSASA from 2006 to April 2015 on a monthly retainer of 57,000 including VAT, or 50,000 excluding VAT. This amount never changed. The only occasions on which I was paid 100,000 per month were when I had not been paid my retainer in previous months. It is for these reasons that the average of my receipts from BOSASA for the 107-month period was only 58,461 Rand 57 cents as an average. 3, Papadakis could not have received cement in 2009 as compensation for influencing a major SARS investigation, as no SARS investigation occurred over this period. And indeed, the first audit conducted only commenced 2 years later in 2011. And Chair, I think the investigators of the Commission have done a very good job in assembling a lot of the evidence for us, which speaks to exactly when cement was delivered. I remained silent in my previous affidavits because I was advised by Advocate Willis to do so because Mr. Papadakis had not responded and he did not believe it was necessary to cooperate with this Commission, whereas my view is I had to cooperate and we had to get to the bottom of this. I could not have facilitated any payments to Radhakrishna in return for awarding a 5-year extension to the Lindela contract when verifiably no such extension was ever awarded. So, Chair.
Sorry, Mr. Chair, could I again interrupt at that juncture? It is necessary with your leave. Mr. Chair, Mr. Wakeford has referred to both Mr. Radhakrishna and Mr. Papadakis. He just referred to the fact that we awaited, particularly Mr. Papadakis' version, which was promised to us, as Mr. Nochi will confirm, some time ago, the last half of last year, in fact. We received, as was submitted to you yesterday and you were informed by Mr. Nochi, we received the affidavits of Mr. Papadakis, Mr. Radhakrishna for the first time, as well as Mr. Agritzi's response to the affidavit of Mr. Radhakrishna yesterday morning for the first time. They have not been worked into these affidavits, but they will be before you, and you have regard to them. But they are both very powerful affidavits, which entirely support what Mr. Wakeford will testify to you today. We aren't going to be making, or he won't be making much reference to them because of the time constraints. Thank you, Mr. Chair.
Okay, all right.
Chair, just on that, no longer any wrong impression be created. The affidavits were not made available to Mr. Wakeford's attorneys because the investigators were awaiting the response of Mr. Agrizi to those two affidavits. We got the response of Mr. Agrizi, hence then we gave them the affidavits at this stage.
Okay.
Yes, indeed so, Mr. Chair, that I should have maybe indicated. Mr. Notchi only received that the night before.
Yes.
So there's no blame imputed to the Commission. Thank you.
Okay, all right, thank you.
Thank you, Chair.
You may continue, yes.
So, Chair, what I've done is I've spoken to what I believe is the nexus of everything I'm going to say today, but merely to unpack it more and to, as some consultants would refer to as a deep dive, and to have a good look at everything. And I'm happy to be stopped at any stage, Chair.
Yes.
If you feel...
No, that's fine.
And Chair, I'm going to attempt not to ramble on. So I'm going right back to the beginning of this affidavit, which starts on page 85, BOSASA 04852. But Chair, with your permission, I'm going to dispense with the formalities.
Yes, no, that's fine.
So what I depose to the introduction, because I've spoken to a lot of that already.
Yeah.
And even in the denial, Chair, just to say that for the record, I deny what has been said.
Yeah.
Then I move on, Chair. I'm not going to go into the prologue, purely because I think as we get into the meat of it, a lot of the substance there will be covered, and I don't want to whinge and whine about my Rule 3 rights that have been abused. Because we all adults and we all have to, sometimes I think Advocate Pretorius referred to as there is always collateral damage. But in the interest of the nation, Chair, and the truth, I would like to start on, I'll give you the exact page number, Chair.
Mr. Notcher, you must remember when Mr. Wakeford has finished, before you start your questions, that we should have his affidavit admitted as an exhibit. Yeah, okay. You may continue,
So,
Mr.
Chair,
Wakeford.
Page BOSASA 04865, and it refers to my relationship with Gavin Watson.
Yes.
So the late Gavin Watson, Chair. So I start off, Chair, just to qualify something, because my primary relationship with the Watson family was with Ronnie and Valence Watson. In fact, Chair, I met them as a youngster. I was a student at the University of Port Elizabeth in the mid-80s. I was recruited into an ANC underground cell, a structure that ultimately reported into Mzwai Poliso. I was rigorously schooled in the politics of the underground at that time. And of course, as you would know, Chair, being, as the Xhosa say, a mlungu, it's not very easy at times to operate within a society that was heavily brainwashed, in particular against the Watson family. And you will remember, Chair, their house was burned down, their businesses went bankrupt, the banks pulled the loans and required them to pay back. And of course, it was a disaster for the family. But during that time, Chair, let me say that, and I'm speaking off the script, but let me say that as a family, one could never question their commitment to the struggle for democracy and non-racialism, and the huge abuse that the family suffered, both at the hands of fellow white citizens and at the hands of the state. I remember them clothing and resourcing youngsters who were leaving the country just after the 76 riots and onward. They owned clothing shops, they provided shoes, clothing, and usually a bit of money to get out of the country for certain ANC recruits. I do also remember taking them food, Chair, as a family, because they literally ran out of food. So, during the period, Chair, 1999 to 2002, I was the Chief Executive of the SA Chamber of Business. And during that time, Chair, you will also remember, I'm sure, because I'm sure you know Judge Myburg, I was a whistleblower in terms of the rapid depreciation of our currency. I'd received information from a source who I never disclosed, and I never will. But you will remember that as a consequence of that whistleblowing activity, my life took a very different turn. And as Kies Bruggemans of FNB said, on MoneyWeb Radio, he said Wakeford is now unemployable. So it was as a result of that action, and maybe one day around a fire we can talk about those things if I ever have the privilege of meeting you personally. But I won't extrapolate on that now. But just to say this, that I had to become a consultant because I would never have survived, and my family would never have survived. And one of the consultancies that I did get, and in fact was as a result of the intervention of Valence Watson, who spoke to Gavin Watson and said, surely you can make use of the former SACOB CEO, surely you can add some value to your business. And that's when I was contracted mid-2006 to provide consultancy services, which were varied, and I'm sure if you read the body of the evidence, ranging from business opportunities submitted through to political economic analysis, but really looking at the threats that the business was encountering. Chair, let me just quickly give you an overall picture of BOSASA, because it's unfortunately, in my view, it became the victim of a witch hunt. And it started long before the Zondo Commission. And during that time, Chair, it, in my view, was probably at a practitioner level. It was a company that led the pack in terms of understanding the essence of black economic empowerment and bringing dignity to people. So it was a company in terms of its balanced scorecard, top performer level 1, and I've heard the counter discussions around that, but the truth is, if you went there, everyone was proud of what they were doing. It was managed essentially, with the exception of what I call the fifth column, or a few whiteys, it was managed, as many people would say, by Idaki. And its board was black with the exception of Gavin Watson. The shareholding was 75% black. The staffing throughout, from bottom to top, was black, African. And it wasn't about nominal jobs either. It was about people becoming heavily involved in the day-to-day economic activities of that company. And yes, they won some state contracts. But to say, and I find it absolutely absurd, some people in the press claiming that they had billions of rands of contracts. The truth is that if you had to take Bidvest as an example, Chair, and I'm not targeting Bidvest, but Bidvest, which was a mainstream company with, I'm sure, a lot of white management, but they had massive state contracts, and they still do to this day, from gardening right through to security, to catering, to logistics, huge state contracts. I'm sure BOSASA would be a little pimple in terms of what Bidvest had in the broader political economy. And I'm sure I can refer to other examples as well, but for the sake of time, I won't. But to say, Chair, that I believe this company, and that's what motivated me as a person and as a professional to see where we were under threat. But why were we a threat? We were a threat, and I say we because I was merely a part-time consultant. I had other clients. But I stuck with them without an increase for 9 years. I stuck with them because I believed in their vision. Else I would have walked away. And the vision was put into practice. And the vision was empowerment cannot be about passive shareholding by African people. Empowerment's got to be about the workforce having a share and about black ownership, or at least black control of a company. And that's what it did have. Chair, I met a youngster the other day who was facilities manager at the Krugersdorp campus, the HQ of BOSASA. And he recognized me at a hotel in Houghton. He was the facilities manager, today as a waiter. It gives you an idea of what Gavin Watson and others did to uplift people. He took youngsters out of the juvenile criminal program and brought them eventually before judges and had them exonerated or given some form of relief and employed them, Chair. Employed them. And they became leaders within the organization. So, you know, this picture painted of the Watsons generally and of Gavin in particular is not true. And I must say this because I believe at some stage there will be a more balanced view in our societies. But the Watsons give white people credibility and legitimacy in this country. If it weren't for people like that, and I'm sure there are others, and one can name them, Neil Agate, Joe Slovo, one can go on and on. But the point is, it is those people who played township rugby and then built companies that were empowered and that treated black people as equals, not as economic slaves, not as subordinates. It is people like that that we should treasure and give national awards to, not treat them like they have sold out the value system of the Freedom Charter. They haven't. So, Chair, if I could then leap into my relationship with Agritzi, because it gives context. And that is, it starts on page 04866. Chair, my relationship with this man was tenuous and unproductive from the very start. My appointment had been suggested directly by Gavin Watson and by the Watson family in 2006 due to his personal experience with me, which I believed angered Agritzi as he saw anyone who had a direct relationship with Watson as a threat to Agritzi's own relationship with Watson and control of the business. And I'll talk about control of the business just now, Chair. Sometime after meeting Agritzi, I expressed to Watson my concerns about Agritzi's character and attitude. BOSASA was a growing black economic empowerment business which could become a benchmark for how black economic empowerment principles could be successfully implemented. Agritzi, on the other hand, appeared to view economic inclusion and Afrocentricity as a burden rather than a necessity. I remember going to, and I'm not going to read this direct, I remember going to the Silver Star Casino Conference Center in my early days as a consultant there to speak about corporate governance and my experience at the Commission into the Rapid Depreciation of the Rand, etc. And Agritzi came to me afterwards and said to me, and I can't remember his exact words, but that he didn't really believe that or have confidence in black management or leadership, in spite of trying to portray himself as otherwise to Watson and the board of directors at the time. And let me also say, he ingratiated himself to such an extent that my relationship with Watson was tenuous as well, because I challenged him on a number of matters. And his excuse was, oh, it's the Rainbow Nation now, Kevin. Everyone, you've got to give everyone a chance to transform. Strangely enough, Chair, he admitted to you in oral evidence that he said, Chair, I am a racist. But he concealed it for a long time. For a long time. Strangely enough, Agritzi, in his affidavit to the Commission on the 8th of April 2019, denied my claims as to his racism and attempted to reposition, and that's interesting, Chair, when you see my founding affidavit, my response to his allegations, and then all of a sudden, he must have had an opportunity to read it, but his story changed significantly in his second affidavit in relation to the evidence, the time frames, and in relation to some of the things that he'd admitted to in this commission, including racism. He says in his second affidavit, which is not in the public domain, I was one of the persons who implemented and managed a diverse, multicultural balance of competent black management and staff in my role at BOSASA. In fact, not only assisted in black management and leadership, but I devoted many years in not only training, but assisting the competent individuals that were employed. On the 2nd of September, Chair, 2018, however, City Press had published a 23-minute recording of Agritzi on their website, the authenticity of which they had verified. Short excerpts of this recording were played during Agritzi's evidence before this commission. Agritzi attempted to suggest that the excerpts of the recording were not indicative of the whole recording, which Advocate Pretorius said was not in the possession of the commission at the time. I therefore provided a transcription of the full 23-minute recording in my bundle, Chair, and I'm sure you'll have a copy soon under EA 18, and tender providing the commission with the authenticated recording itself. So, Chair, if it's required, one of my team have it for you. In the recording, which was made by Agritzi at his home on the 4th of August 2018, he said about black people and Africans, Chair, they steal, they loot, they rape, they destroy, in reference to the black community collectively. Agritzi then referred to a friend of his, Romano, saying that he was not a racist, he's a realist, for his view on black economic empowerment that he would not let a bloody K, meaning the K word, Chair, run his business. This confirmed Agritzi's own view on black economic empowerment, Chair. This is in stark contrast to what Agrizzi said at the Commission on the 16th of January 2019, when Agrizzi said the country was changing for the better. And we saw the BE credentials, we saw that BE credentials played a major role. In the same recording of Agrizzi on the 21st of August 2018, Agrizzi says, 1, referred to the black directors of BOSASA as monkeys by referring to black director Trevor Matenjwa as his pet monkey, Romeo. And Chair, when you see the evidence later, you'll also see that he has a monkey at home that he calls Romeo. 2, referred to the black directors of BOSASA as dysfunctional. 3, I will personally go into that company with or without permission, and I will F each of those Ks out of there, referring to the black directors of the company. Stated that that K needs a good hiding, referring to respected attorney Peter Chesive, and stated, I'll teach each one of those Ks where to get off, once again referring to the black directors of the company. And 6, stated that the black directors of the company were not competent. It is clearly a lie by Agrizzi to suggest to the Commission and his representations to it on the 8th of April 2019 that he is not a racist, and that his belief is that these very same people he referred to as monkeys, dysfunctional, rapists, thieves, and looters are suddenly a competent black management and staff, in his view, and that he, in fact, worked very well and had a good relationship with the black directorate. Indeed, there could be no greater proof of Agrizzi perjuring himself in his affidavit to the Commission of the 8th of April 2019 by denying my claims as to his racism than Agrizzi specifically stating to Chairman on the 29th of January 2019 in his oral evidence, Chair, I'm a racist. So, Chair, the other thing, and I'm not going to talk to script now, but the same page, the other thing that I think is very important for the record is that this man was the de facto CEO of the company. He had built an institutional moat of control around Gavin Watson. He even referred to and responded, certainly at that point in time, to Gavin Watson's emails. There are board resolutions, which you will see in the evidence, where even in terms of some of his criminal activities, where him and Van Tonder, the CFO, were the sole CEO, that they were the guys who signed almost everything. And they were empowered to by the board. In terms, although there were other people who could have signed, there was a list of people, they were the two signatories in the main, from dealing with the banks, to dealing with issues of finance, to dealing with issues of procurement, approvals, and signing off payments. Gavin Watson, as we all know, was not a detailed man. He was a charismatic figure, someone who loved the people, spent time at the youth centers with, juvenile delinquents. He just loved people. And he managed by walking around. He didn't even have a desk or an office, and he very rarely used a computer. Agrizzi was the CEO here, Chair. As much as he denies it, and there's evidence to back it up. But he wasn't called the CEO, he was called the Chief Operating Officer. And it is my view that if anything went wrong, that he was inextricably part of what went wrong at BOSASA. And I warned Gavin Watson about him on several occasions to say, this man is up to something. Because I would bring opportunities for the company, none of them were considered. Not one. You can't tell me every single opportunity wasn't a strong business case. Chair, on to the next page. Agrizzi actually says, he says, I deny that I control Gavin Watson's email account and that only emails that I received from Kevin Wakeford, I've given examples of the same which have been attached here too. But Chair, if you look at a lot of the evidence that can be considered here, certainly in my pack, and I do refer to where one should go in terms of the references, it is very, very clear that there's proof where he even responds in one email to say, don't bother about emailing Gavin, because I'm responding to it anyway. He actually says it. So, Chair, you will also know, and I'm sure you've read my prior affidavits, but there's sufficient evidence to prove that, and the investigators even had sight of my bank details. But where he says I was paid 100,000, the evidence speaks to a very different scenario. Firstly, way outside of the time frame of the so-called SARS investigation, and secondly, Chair, those payments are proven catch-up payments where he, to frustrate me, deliberately didn't pay me. For months at times, Chair. But because of my commitment, in particular to the family and what they believed in, I continued to assist. And then, and if one looks at the section 7417 minutes where him and Van Tonda contradict everything, and Foster, that they said in front of you. Everything is contradicted. They've perjured themselves, Chair. They've committed a criminal act. And both those activities, the one took place in front of you as a judge, and the other took place in front of Judge Joffe, who was a commissioner at the section 417. So, Chair, I'm worried about your time, so I'm trying to...
Yes.
Are you okay with the way I'm doing it?
Well, we just wanted you were going to give an overview,
yes,
or at a high level, and then let Mr. Noche direct you to questions to you in regard to more details. Do you need another, 15 minutes, or how do you feel?
Oh, Chair, no, I'd need more than 15 minutes.
Sorry?
I'd need more than 15 minutes.
Okay, how much time do you need?
Chair, I think if you could give me an hour and a half.
Then you will have completed.
Yeah.
Okay, let's see where you are by 11.
Okay.
When we take the tea break, preferably when we come back, maybe we could look at questions, because you will still be able to deal with other issues. Mr.
Sure.
Nocha, is that fine with you?
I'm happy with that, Chair.
Okay. Counsel for Mr. Wakeford, do you think that's fine?
Mr. Wakeford may need a little bit more time, but Mr. Chairman, you're correct. Let's see how we go. Thank you. Chairman, can I just take the opportunity, of course, because you don't have the bundle of annexures before you.
Yeah.
Mr. Wakeford's not referring to it, but of course,
Later
for those who
on.
can't see it, everything he's speaking to is referenced with annexures, and there's about 330 odd pages of evidence that he's not speaking directly to because of time constraints.
Yes.
Thank you, Mr.
Okay,
Chair.
no, that's fine.
Chair, I'm seeing what I can skip if I can.
Hang on, I think the evidence leader is disturbing everybody with the gestures. but he was trying to arrange for water for you, Mr. Wakeford.
that's
I
very
think
kind.
the commission staff will make sure he has got water.
Thank you, sir. Thank you very much.
Okay, all right. Thank you.
Okay. In his affidavit to the Commission on the 8th of April, he said, I did not have a bad working relationship with Kevin Wakeford. There was no major conflict between us. It was the dire situation of Kevin Wakeford's financial system, and that there was one financial hiccup in my system, Chair, and that was it. And that I prove, and I provide you with evidence. The Commission's investigators have, however, confronted Agritzi with an email dated the 7th of March 2012, where he says, Carlos, this was done as agreed when I reduced Kevin Wakeford, talking to the amount I receive, for March, and 50,000 for Feb. We are well behind it, but I will manage expectations on his side. The consultant is using the attached vehicle to channel payments. And I'm not exactly sure, but clearly he was the person who was adjusting and playing the fool with my payments, Chair. When asked for comment, I was informed by the Commission that Agritzi responded, during this period, the company was under cash flow pressure, and Mr. Gavin Watson instructed me not to make further payments to Kevin Wakeford. So, Chair, if you go to page BOSASA 04873, Chair.
Yes.
It refers to the Section 417 transcripts, where Advocate Lawrence is questioning Van Tonder, the former CFO of BOSASA.
Sorry, Chair, if I can just make submission in this regard.
Yes.
Sorry, Chair, I've just been told just to remove so you can hear me.
Yeah,
I can
no,
just
no, that's
make a
fine.
submission at this stage with the utmost of respect, Chair.
Yeah.
The Section 417 inquiry, which was held before the learned retired Judge Joffe at the offices of MacRobert Adams, was a secret inquiry. And in terms of that secret inquiry, I'm not sure how Mr. Wakeford and his legal team are now in possession of what is supposed to be a secret inquiry. That is the whole purpose of the Companies Act. So reference to this, in order to try and substantiate the whole promotion that Mr. Wakeford, with respect, is giving of the great Watson family and all their BEE credentials and what they did, and now using secret inquiry documents which should not be before this commission or in the public, because the learned judge on many occasions in that matter made it clear that it's a secret inquiry and those documents cannot be released to anybody. So I'm not sure how they've come into possession. Perhaps my learned friend, who appears on behalf of Mr. Wakeford, can explain how they've come into possession of secret inquiry documents. And I think the slant that Mr. Wakeford, with respect, is trying to put on this in order to bolster and try and promote his relationship, his university days, the whole scenario that he's given might have a serious impact in regards to the effect of his evidence. So if we could just deal with that aspect, and I'd like to just raise that at this stage.
Yes.
Because on many occasions in that inquiry where I was present, the learned judge made it clear that, and he put it on record before we started, it's a secret inquiry. There were only one or two people that were privy to it, and none of this can be put in the public domain. That's the very purpose of Section 417. So if we can just deal with that and get some clarity as to how this is now in the public domain from what is, then it defeats the whole purpose of Section 417.
Yes.
So if we could just deal with that with respect. Thank you, Chair.
Yes. Would you like to respond?
As you please, Mr. Chairman. Chair, indeed, we've put up extracts, a number of extracts, I think 7 or 8, that come from the 417 transcript. In each instance, we put them up because they show Mr. Agrizi and Mr. Foster to have perjured themselves and lied under oath before Judge Joffe. There are extracts in relation to evidence by Mr. Van Tonder, who, in fact, supports, on a proper understanding of his evidence, Mr. Wakeford's evidence. We asked the Commission to obtain...
I'm sorry, that's you're dealing with the purpose of referring to it. I think Counsel for Mr. Agrizi raises the legality of putting it in the public domain. And
indeed, sir.
Yeah, that's the issue he's raising.
Indeed, sir, Mr. Chairman. That's the relevance of the information, firstly. We first approached the Commission last year in October and asked them to obtain a copy of the transcript, and we placed that relevance before the Commission to the Secretariat. Of course, we did so because this Commission has powers to obtain that transcript. We obtained no response. There may have been one response. Mr. Notchi said to me yesterday that he believed that there had been a writing to say that we should obtain it ourselves. I looked through the correspondence. I didn't find that, but certainly from Mr. Notchi's side, he believed he'd dealt with the issue. Of course, from ours, it had not been dealt with. We followed up in a number of written items, both to the Commission, and we directed directly to yourself, asking for a meeting to sort these things out and obtain in particular, there were other documents, but obtain in particular this transcript because of its relevance. In the meantime, we tried to obtain that document ourselves through the Master's Office. The Hawks tried to obtain a copy of their document too, we know, and for whatever reason, it wasn't forthcoming. What the person who has given that document to us is Mr. Jared Watson. He's the nephew of Mr. Gavin Watson. He's also the representative of one of the shareholders in the BOSASA liquidation. He, as of right, was entitled to a transcript and obtained that transcript. He informed our client, who informed us that there were these contradictions.
That?
There were these contradictions.
Yeah.
These perjurious contradictions that I've referred to initially, and the support by Mr. Van Tonder, or the support of his evidence, should I say, properly speaking. And he was not willing to surrender the document to us to place, or the extracts to place in the public domain. He wanted us to obtain not the permission, but a subpoena. You will recall that this issue came before you yesterday, and your attitude was that under the circumstances of pressure, with us adjourning yesterday, you weren't at that stage prepared to issue a subpoena. When we retired from here, Chairman, we went back to my chambers, and there I called for Mr. Watson to attend at my chambers, and out of Mr. Wakeford's respect for him, we asked him one more time to consider his position. We took the position that, notwithstanding previous advice he had taken, or his own belief and understanding, that there's no real reason for him and that he's not properly prohibited, he's not actually prohibited on a proper understanding of Section 417 and the law in relation thereto, he's not actually prohibited from giving it to us. In fact, anybody can use it in criminal and civil proceedings, and I say that subject to the qualifications that are contained in Section 417 and a commentary in the various authorities that deal with it. And without pressurizing him, we did prevail on him to reconsider. He left us for a number of hours, and he went and consulted his attorneys and whoever else and took advice. He came back to us, and he made the election to then allow us to publish it. And that's why you find it in this format, in the affidavit, notwithstanding us not obtaining a subpoena from yourself. The nub of the... Sorry, might I just take an instruction?
Yeah.
What had been taking place behind the scenes was an effort an attempt to get through to the right channels within the Master's office. And I'm going to read to you that we've just received that permission from the Master's office. So as I sit now before you and as I lift this phone and give you my assurance as counsel in this matter, on my instruction, as I haven't read it, this is the authority by the Master's office. But the nub of the matter, were we not to have received this, the nub of our view is that the Commissioner in a 417 inquiry does not have power to either prohibit or to entitle anybody to use it and publish it. Whatever cautions and warnings were given by Judge Joffe in the Commission, no doubt, were given pursuant to Section 417 and obviously general understandings of 417, etc. However, we hold the view that some of those understandings are sometimes misconstrued. I'm not saying that Judge Joffe misconstrues them, but certainly other persons often do. It is the Master who holds the power to order. Yes, sometimes that can be, and in many instances, specific powers are delegated to commissioners, such as Judge Joffe. But there was no real prohibition in our view. We asked Mr. Watson to go and have that considered by his legal representatives. He came back. I don't know what advice they gave him. I did not want to know that. But nonetheless, an urgent letter was again dispatched yesterday and delivered to the Master's office. Yesterday, both the Master and the Assistant Master were not available. However, and we can place this before you as soon as we can have it printed up, we now have the permission of the Master nonetheless. So the matter is, in our submission, now moot. Thank you, Mr. Chairman.
Obviously, both Mr. Noche and counsel from Mr. Grizi would need to see the permission. But I think that it may be that it might be better that we don't, that Mr. Wakeford doesn't refer to these extracts for now. Maybe later, until I'm also satisfied that it's in order to do so, but also until counsel for Mr. Chris has looked at the permission and reflected, and Mr. Noche. So I suggest that Mr. Wakeford skips this part for now, and then we can look at it later in the day.
Might I just say, thank you, Mr. Chairman. With your leave, might I just say that there is an introductory paragraph that deals with the fact that he's been reliably informed with the briefest of summary, and then he can stop at that point, if I could suggest that, for his ears, and then not quote from the quotations which are set out. And of course, the extracts are attached, but he won't quote from it. Thank you, as you please, Mr. Chairman.
Is that the one is that paragraph 84 that you're talking about? However, I'm informed.
Mr. Chairman, if I could just get there. However, I'm informed that agrees his accomplice, etc., etc. So he would read that paragraph, and then. Well,
what I would prefer is that let him not read it now. Let him, if later on I say no, he can go ahead and read the extracts, then he can introduce the extracts by first reading it at a later stage.
Mr. Chair, if I could just, with your leave, please prevail on you and also test my understanding.
Yeah.
In the next paragraph, 85, is the actual extract.
Yes.
84, to which I've alluded, is merely the briefest of summary, in which he says, however, I am informed. And he's entitled to place that evidence before you as to what he's informed in the briefest of terms. He's then not placing the extract before you. I would, with your leave, prevail on you to allow him to read the paragraphs before, but not the paragraphs with the extracts. As you please, Mr. Chair.
Excuse me. No, my difficulty with that is that I must just look at the relevant provisions first. You know, even with the summary, it's better that I look at the relevant provisions. You have indicated that it's the master who must give permission,
yes,
and not the commissioner at the 417 inquiry. Counsel for Mr. Grizi seemed to proceed on the basis either that the statute doesn't allow it, or the commission, once the commissioner has said it's secret, that should be the position. So before Mr. Wakeford says, even if it's not the extracts, he says what he understands has been testified to at the inquiry. I would like to just have a look at the relevant statutory provisions and the permission, so so I satisfy myself that even saying what has been said there in your own words is okay.
As you please, Mr. Chair.
Yes.
Thank you for your time.
Okay, all right. So, Mr. Wakeford, for now, let's keep this part. Let's keep this part. You proceed, and then at some stage we will come back to it.
Thank you, Chair.
Chair, can I also make a suggestion? Oh, it's
Yes.
me.
Sorry?
Can I also make a suggestion
Yes,
to Mr.
yeah.
Wakeford? Mr. Wakeford, I think you have demonstrated with the extracts you have referred the chair to, your relationship with Mr. Agrizi, his attitude to race relations. Can you move, because before I even ask you to move, this affidavit is going to be admitted. The chair is going to have the affidavit. You have told him that Mr. Agrizi's relationship with you was X, as you referred him to the extracts. You have told him Mr. Agrizi's racist relations. Now, the chairman has got that. And if I may ask you, but I don't want you to skip what you want to place, to move, for instance, your next topic was going to be your position as the CEO of AMSCO, to move to that. Are you happy with that? For instance, if you were to move to page 877.
Oh, I think, Mr. Noche, what you mean is that when you look at what appears after the extracts,
Yes.
up to just before the next topic, it seems that a lot of that is about Agrizi's attitude to black people and so on.
Yes, that's what I'm saying.
So you're saying,
Which point has been made?
yeah, okay.
Chair, if I could just, with your permission,
Yeah,
speak to the end of my relationship with Agrizi. I think it's very important for the
Yeah.
evidence.
yes,
That would be on page BOSASA 04876.
yeah, okay, all right.
Yeah. Chair, this all came to a head before he was exited, for want of a better word, out of the company. I was, at that time, the CEO of AMSCO, but I still retained a relationship with the Watson family. I mean, some of their children are godchildren to me as well. So, one continues with relationships. One doesn't just move on when you don't have a consultancy. But safe to say, Chair, that in late 2016, we were having coffee. It was myself, Valence Watson, Gavin Watson, Jared Watson, Daniel Watson Jr., not Cheeky. And Gavin got a call from Agrizi to say, can he pop in? And at that coffee session, for want of a better word, in the course of discussions, Agrizi began ventilating his anger with the board of directors of BOSASA, and then made the following joke: there are only two things I hate. This is his words. The one is a racist and the other is a bloody K. I immediately confronted Agrizi, objecting that he's speaking of our brothers. You don't speak of our brothers like that. To which he said, don't be so sensitive, it's just a joke. Then Agrizi left. When he left, we discussed the incident. This was again confirmation what I suspected of Agrizi all these years, that he was a racist. I believe that it was shortly after this that Agrizi's employment with BOSASA was terminated in early 2017. Among the reasons Agrizi's employment was terminated in March 2017 were, 1, his offensive and racist language towards the Black Board of Directors. 2, his autocratic behavior and complete disregard for the authority of the Board of Directors. It had come to light that Agrizi had employed numerous friends of his within BOSASA without going through ordinary human resources processes. And 2, he had awarded substantial salary increases to acolytes of his within BOSASA without going through the REMCO or Remuneration Committee. This is evident from the minutes of the BOSASA board meeting of the 9th of March 2017, where inter alia, the retrenchment of these employees is discussed. His cronyism and clandestine development of a fifth column within the BOSASA group. And Chair, as I go on, you will see that this notion of a fifth column isn't conspiratorial. It's about developing a grouping within an organization that technically pursue their own agenda within the organization. As we go through this, a lot of that will be uncovered as well. Chair, but if I can move on to page where Advocate Noche has asked me to speak to my position as CEO of Armscor and some of the political machinations there. Chair, just to summarize a lot of this, I was appointed on the 1st of May 2015, and contrary to some public commentary, the appointment was a rigorous process. For the first time in many years, had to do competency tests, etc. And I was told once I'd been appointed that I in fact outperformed all the other applicants. At no stage during my employment did Watson or BOSASA try to exploit their historical relationship with us. And I think I have attested to the fact that during my tenure we had 3 clean audits as well as an unqualified audit. But this wasn't the case of Agrizi and his son Giancarlo, who attempted to muscle in a company of Giancarlo's on defense and security matters, policy analysis, etc. Even though he was a student at the time, and Agrizi speaks about that ad nauseum, that his son was a student, but you'll see the CIPC records and the LinkedIn adverts and the social media adverts, where the company had been in existence for quite a while, albeit with students populating the shareholding and the board, etc. Interestingly enough as well, that company's directors were all linked to the Democratic Alliance, and there's proof of that, albeit that Giancarlo, who attacked, and the company's name, Chair, is Ndlala, trading as Ndlala. But the point I'm really trying to make, Chair, was that every relationship that this man had was exploitable.
Just give that spelling of Indlala for the benefit of the transcribers. Indlala, the spelling is I-N-D-L-A-L-A. That's just for the benefit of the transcribers.
Thank you, sir.
Yeah, okay, all right, continue.
So, Chair, I'm not going to go into all the detail of the evidence.
Indlala, of course, means famine, hunger, starvation. That's what it means.
Thank you, Chair.
Yeah.
I didn't know that. But the real point, Chair, is that Mr. Giancarlo, after accepting a post within the ANC for a while, sustained that company and sustained his relationship with his fellow DA directors. I'm not sure whether the African National Congress was aware of that, but that just gives an idea, you get an idea of the value system, the duplicitous nature of the people involved. But more so, Chair, that Giancarlo came forward before the democratic elections of 2019 and made certain claims to discredit Gavin Watson as well as the ANC, even though he'd worked there, and then a number of months later retracted everything with the Citizen newspaper. Chair, it's quite a lot that I say there, but even Agrizi's relationship with the DA, there are videos of him being visited by Glynis Breitenbach, Werner Horn. I think Breitenbach was is the Shadow Minister of Justice, and Werner Horn, the Deputy Minister, Shadow Minister of Justice, and Agrizi often used to brag about that relationship that he had with certain individuals, including Glynis Breitenbach and Werner Horn. But I'm not going to get into more of the detail of that, Chair. Safe to say that, could I move on to why would this man perjure himself to the point of extinction by attacking me so viciously? Why would he? And I think you've asked other witnesses in other work streams as well, why would this person lie about you? Why would they say all these things? So, Chair, I've tried to, and I'm going to read from part of it, and then from part of it I will summarize.
Yeah, okay.
But just to say, and that is on page BOSASA 04884, Chair.
Thank you.
Further to what I've mentioned above, which evidently motivated Agrizi to falsely implicate me in alleged corruption at BOSASA, namely, 1, our contentious relationship, given my historical relationship with Watson and the broader Watson family, my non-racial values versus his racist values, and my questioning of his character and value system from the onset, Chair. 3, his perception of my part in the termination of his employment with BOSASA. 4, my usefulness to Agrizi in all the circumstances to promote the interests of the Democratic Alliance. And there's an overarching context, including how, when, and why, in fact, Agrizi manufactured his allegations, and important timelines to be understood and factored in order to consider and weigh Agrizi's allegations before the Commission. He confirmed in his oral evidence on the 18th of January 2019 that a meeting was held with alleged whistleblowers, and Chair, none of them are whistleblowers in my view. They use the term very liberally. At Agrizi's home on the 12th of November 2017. The following must be noted. Calling them whistleblowers is a misnomer at the very least, because they were either being coerced by Agrizi to make false statements or were in cahoots with Agrizi in his nefarious plans and or were acting purely out of self-interest. This was confirmed to the Commission on the 26th of March in his oral evidence, in the oral evidence of Petrus Stephanus Venter, a former employee of the BOSASA auditors, Darcy Herman and Co. Incorporated, and who attended that meeting at Agrizi's home when he said he has made to prepare a statement. So he came here and told you, I was coerced. It was written for me by Agrizi and I had to fill it and sign. In his affidavit of the 11th of November 2018, Venter said that Agrizzi, in fact, had drafted his statement on his behalf and that Venter merely had to type in his personal info. Venter says in the same affidavit, Angela made various threats pertaining to my career and personal well-being in an attempt to intimidate and blackmail me and to get me to sign the statement that he drafted on my behalf. And I signed the statement under duress and due to the constant intimidation and blackmail from Agrizzi. And Chair, I think that speaks for all the people who visited that day in order to blow the so-called whistle. Their affidavits apparently were prepared for them by Agrizzi. In Venter's affidavit to the Commission annexed, and I've got it here, Chair, revealed, as he did on carte blanche on the 3rd of February 2019, Agrizzi's corrupt activities, coercion and control of people, including Venter and his plan to destroy Watson and BOSASA. I refer to Venter's affidavit to the Commission and in particular the master plan. So, Chair, to summarize, the master plan, after a series of engagements post him leaving, where he tried to take over contracts of BOSASA and engage them on that. Then he tried to go back to BOSASA and engage them. This is after his Damascene experience. This is after having his tumor cut out where he said, I sat with my family and I wanted to come clean. Well, it took him more than 2 years to come clean, Chair. It was only after Babale Shabani and Joe Gomede went to the police station to file criminal charges against him that he decided that he was going to interact with the Commission. So furthermore, Chair, Forster's affidavit was commissioned the following day on the 13th of November 2017. The very affidavit he brought here in 2019 was prepared 2 years prior to that, or was prepared to be exact, Chair, on the 13th of November 2017. So, Chair, I'm going to skip quite a bit.
Yeah, that's right.
And
well, I just want to say, Mr. Wakeford, that unfortunately, most of the directors of BOSASA who could have come here and said what they may have to say about Mr. Agrizzi's evidence did not cooperate. They were given, including the late Mr. Watson, they were given what we refer to as Rule 33 notices, as well as other people like, I think, Mr. El Shabane and others, Mr. Kumede. One, they didn't respond, but in a way one can say in regard to responding to 33 notices, they were not obliged to. But the Commission was very keen to hear what they have to say, to the extent that I issued what we call Regulation 10.6 directives against them, including Mr. Kevin Wakeford, to say, come and deal with these matters. Unfortunately, they did not respond. And when Mr. Kevin Wakeford passed away, there were some discussions from the reports that I was given from his lawyers, but the approach was not really one of being keen to come before the Commission so that they could deal with these issues. So it's good that to the extent that you may be aware of some of the matters yourself because of your relationship with BOSASA and with Mr. Kevin Wakeford, you are able to deal with them, to say this is the position. But I just thought I would say that, you know, it's a strange situation where people are there who could come and say, that's not true what he said about us here. But they don't want to come. So to the extent that you interacted with BOSASA and with Mr. Kevin Wakeford and you know certain things, it's good that you are able to deal with them and put before the commission what you know.
Thank you, Chair. Chair, if I could respond to your statement. Look, there are two schools of thought in South Africa about this commission. The one school of thought is that it's politically weaponized and it's going for a particular caucus. The other one is that it's here to seek the truth and to establish the truth. And I've opted for the second, for the latter. I believe you're a good man, and I believe that you are someone who's just trying to clean up society in South Africa, and in particular, our public institutions. But I'm sure that you also would want to clean up some of our private sector institutions. Chair, I haven't had contact with the board of directors for a long time. Safe to say, perhaps we have a different view. It is a pity because, and perhaps me appearing here will encourage some to come forward if there's enough time, of course. But I think it is a pity that there are these two schools of thought.
But it is a pity, and I mean, obviously, I know about the two schools of thought generally in society. And obviously, people are entitled to form an opinion about a public body such as this. But I always have difficulty understanding this part. If the commission wants to make findings against you, Mr. Wakeford, it wants a certain outcome about you, why would it try so much to hear your side of the story? Because is it not easier to come to that outcome without your side of the story? Because you might come here and give very good and plausible explanations for things and therefore spoil the plan. I've not understood that part. And also, I've been told, I think it's more than 250 witnesses, if I'm not mistaken, over the past 2.5 years or so. Of those, maybe there are 1, 2, or 3 who have expressed unhappiness that they have not been treated unfairly. The overwhelming majority have not expressed any unfairness. I mean, I continue to hear some of the people who are implicated, and seriously implicated, and I would like to believe that I give them enough time to put their side of the story. And when they articulate their concerns, I say, let's look at those concerns. Let's look at those. Some of them might have merit, others might not have. But let's look at those. And when they say, here is some evidence about that witness who said ABC about me, I say, let's look at that, you know. So, but obviously, you know, people will have their views. And and there is nothing one can do. From our side, we must just continue to do what we believe is right, try to be as fair as possible. It doesn't mean that we won't make mistakes along the way, but let's keep on trying to do the best we can. So, yeah, okay.
Thank you, Chair. Chair, just to respond to, for me, I was incredibly frustrated because I responded fairly quickly with my first affidavit. My application was to cross-question. And I understand the process, that testimony first, then cross-questioning. I'm not sure whether I'll ever get an opportunity to cross-question a Gritzi. Albeit that he was recently seen in Franschhoek without an oxygen tank or a mask with no walker. And their Instagram videos flying around South Africa on that at the moment. But even if I don't, Chair, I've got to do this, and I've waited. I've waited 28 months.
And you have got the opportunity now.
I've got now my opportunity, and I'm going to use it. I'm not going to whinge and whine.
Okay, thank you.
Thank you, Chair.
Okay, thank you.
So, Chair,
I see we are at 1:15, which is when we normally take the tea break. Maybe let's go to 1:30 and then take the tea break then. Okay.
Thank you, Chair. I'm going to continue with my motivation, which I've summarized because it's quite long. But to say this, that on page 888, without mentioning BOSASA 04 every time, you see his plan when he was exorcised as the de facto CEO, then he tried to come back, and it was upping and downing, and it's all in my evidence. His plan was, we'll put you under pressure, and even if we have to see you liquidated, and I wasn't there at the time, Chair, but the evidence speaks for itself. The plan was to trigger the media, to trigger the auditors. You know what auditors do even if they hear of something suspicious. Even the banks in this country just close your accounts with a person being potentially innocent. But thank God my bank didn't close mine, but there are many people who had their bank accounts closed without any evidence to the effect that it was just rumor-mongering and fear. And society in South Africa tends to respond at times very similar to the Salem witches story, where innocent women were hung in Salem because they were deemed to be guilty by the public gallery. And we need to manage these things very, very, very carefully in South Africa because, unfortunately, these things cause more polarization in society. But his plan was, at the very worst, the worst option for him, of course, was liquidation. But he got his liquidation. He got it. And 6,500 families out of work. And Venter confirmed all of this in his affidavit, Chair. Gritzi's plan was premeditated, calculated, and executed to instigate the liquidation of BOSASA so that he personally would be able to take over BOSASA's contracts and no longer be bound by his restraint of trade. Indeed, BOSASA went into liquidation in February 2019 as per his plan. This wasn't a man who was blowing the whistle, Chair. With all due respect, this was a man who was greedy, he was narcissistic, and he wanted to be back in the seat of the king. That's what he wanted. Chair, I mean, even the banks panicked. The banks panicked during that time. The auditors panicked. Even, I think, Gavin Watson panicked and went into voluntary liquidation. I'm not sure whether I would have done the same thing, Chair. I would have come here as quickly as possible. But the point is, I tried and I couldn't. And perhaps we could have saved a bit of that company. Chair, I'm not going to read some of the quotes because those quotes, you haven't authorized that yet.
Yeah.
So, Chair, his fifth column even went with him to Criaris when he left BOSASA. Same people followed him. And what they say about him, for Italian Businessman of the Year, just to give you an idea of how he saw himself as the de facto CEO. On the website of Criaris, the company that Agrizzi formed in 2017 after being terminated from BOSASA, he described his influence within BOSASA as follows. Angelo's most recent accomplishments can be noted in the performance of the BOSASA Group, now known as African Global, that he developed from a greenfield operational unit employing only 322 people to a multinational group with 6,515 employees. The website further reveals the management team of the company, this is Criaris, was comprised exclusively of former employees of BOSASA. Once again, the fifth column, Chair. Lastly, Agrizzi said in an email on the 7th of March 2018 to Darcy Herman, the auditors of BOSASA, that when he left BOSASA in August 2016, he was inundated with requests from Gavin Watson to ensure Agrizzi retake control of the BOSASA group of companies. And there, it's all in the evidence, Chair. But just to speak to some of the control that he had when he points fingers at the rest of the world, he says here, yes, Chair.
What page are you on?
We are now on, sorry, Chair, I'm guilty as charged.
No, I'm not charging you.
I should have told you as we moved on. We are now, Chair, on page 895.
Thank you.
He says here, it tells the Commission the payment regimes and protocols required numerous signatures. So you would have at least 4 to 6 signatures on a document to be able to get a payment through and to get an order through. So it would require no less than 2 other signatures. So you would need the originator's signature, the person who is placing the order, plus it would need 2 others, one of which had to be the chief accountant and director. Chair, this is verifiably false, and I've provided the BOSASA company resolutions which demonstrate that Agrizzi could approve any transaction if it was countersigned by Van Tonder. He's someone who he worked very closely with and who left and joined him at Criaris, as far as I understand. Until 2017, when Agrizzi's employment was terminated, Agrizzi and Van Tonder had the collective power to, 1, sign any documents and do all things as may affect and or bind the company and or any of its subsidiary companies in any matter whatsoever, and open bank accounts and deal with financial institutions in any matter regarding the finance and to sign checks for and on behalf of the company, its subsidiaries and associates. Venter, in his paragraph 10 of his affidavit of the 11th of November 2018, confirmed Andries van Tonder and Angelo Grizzi had full control of the company and nobody questioned it, except me, Chair. And I think there's sufficient on the record for that already. It is through this authority that Grizzi and van Tonder were collectively able to siphon substantial amounts of funds out of BOSASA. By way of an example, Chair, Grizzi and van Tonder were the sole members of Synchroprop number 8 Closed Corporation, commonly known as a CC. And you can see the CIPC entity search in the annexures. As the sole members, they would prepare fictitious invoices, send these fictitious invoices to BOSASA, and then authorize them for payment in their capacities as Chief Operating Officer and Chief Financial Officer of the group. In the invoice example attached, you can see that the invoice is approved with only 2 signatories, Grizzi and van Tonder. Venter, in paragraph 8 and 11 of his affidavit of the 11th of November 2018, confirmed his own participation in one such scheme, where Grizzi and van Tonder would instruct Venter to fictitiously inflate invoices, which Grizzi and van Tonder would then approve. The 3 parties would then share in these proceeds of crime, and Grizzi and van Tonder would thereafter instruct Venter where to pay their commissions, as he referred to them. In this regard, payments were made to or on behalf of Grizzi van Tonder and Grizzi's wife, Debbie Grizzi. It is because of schemes such as these that the BOSASA liquidators served Grizzi and van Tonder with letters of demand for 91 million and 21 million respectively. In June 2020, this, however, came after criminal charges had already been filed by African Global Holdings against Grizzi and van Tonder and Venter in November 2019 for theft, fraud and money laundering of 37.5 million. And apparently there's more to come, Chair. These criminal charges further made reference to companies that Grizzi used BOSASA to make payments to, where his wife Deborah Grizzi was the director. This involvement of Grizzi's wife in his schemes was further confirmed by Colonel Bernardus Lazarus, who opposed Grizzi's bail application at the Palm Ridge Magistrates Court in October last year. Here, Lazarus confirmed that Grizzi and his wife moved millions of rands offshore and into cryptocurrency accounts, with Deborah transferring 11.9...
Sorry, Chair, if I can just raise 2 issues here.
Yeah.
In relation to this. Firstly, all that has been verified and confirmed that it was all done with Reserve Bank approval. There was nothing illegal about the transfer. Secondly, I apologize, I had to leave the room. I received the urgent request. The liquidators of the BOSASA and African Global Group say they are very, very perturbed in regards to the fact that reference is being made to what happened at a 417 inquiry. They can be at 2 o'clock and they would like permission, if necessary, to deal with it, because they say, as far as they're concerned, no input or permission was sought from them. The master has not asked for submissions or input, and they would like, if necessary, to make submissions in regards to references that Mr Wakeford is making in this regard to try and bolster and sustain his attack on various issues and credibility. And if he knew the correct facts, and his legal representatives would have approached my instructing attorney or myself, we would have told him that whatever Colonel Lazarus said, all this was done and the true facts were placed before a High Court judge in regards to the bail appeal where bail was granted, very, very simply to say that all this was done with Reserve Bank approval. Nothing was spirited out the country, etc. So the picture that he's trying to paint with respect, Mr Wakeford, in utilising evidence and trying to utilise extracts that support his stance in regards to his obvious dislike, if one wants to put it as lightly as that, for Mr Greasy. We submit that this cannot be used at this stage because these are not the correct facts that he's putting before you. And if he wants the correct facts, we're happy to provide him with the correct facts, and the liquidators would like that opportunity. I spoke to their counsel to approach if necessary. We don't want to turn, I know what the purpose of this is,
Yeah.
we know what you want to do, we don't want
Yes.
to delay it further, but they say there can be at 2 o'clock because they need to address, they find it very, very, and I think it affects not only liquidators and not only affects Section 417 of the Companies Act, but also the presiding Honourable Judge Joffe who dealt with it. This is going to have a huge impact on future 417s, that without submissions and permission, that information is now being put in the public domain, which takes away the whole impact.
Let me say this. Anything relating to what has been testified to in the Section 417 inquiry, I said, let's for now not deal with it. Okay?
Yes.
I said that later on Mr. Wakeford could deal with it after I have applied my mind to the legal position and after I've had everybody. But since saying that, I have begun to think of a different way of dealing with this, and that might affect the question of whether the liquidators or their counsel will come here or not. I'm going to suggest that for today, let Mr. Wakeford give his evidence that he needs to give and leave out one extracts from what may be evidence in the 417 inquiry or his understanding of what evidence has been given there for now. And what I would propose is that maybe each side, your side and counsel for Mr. Wakeford and the legal team, and if the liquidators want to also come in there, that's fine. Give me some short note of the relevant provisions, under what circumstances, what can be done in relation to evidence in a 417 inquiry. But I would like to look at that without the pressure of having to allow this today. But the idea would be that can be given to me in due course, and once I've had a look at it, I can then indicate what my position is, which might not need oral argument. But if I think it's necessary, we can take from there. But one would like to dispose of this without, much, unless it's really necessary in terms of oral argument. But once I have taken a view, then I can let you know. And if I must make a ruling, I can make a ruling. And if the ruling is such that the extracts can be read out and or a summary can be given of what has been testified to in the inquiry, then we can take it from there. If necessary, it shouldn't take long. It might be less than an hour or an hour for Mr. Wakeford to come back and just deal with that. Or we might just arrange that his counsel can, for the sake of publicly showing what they believe supports Mr. Wakeford's version, can then read out the extras. Obviously, if I conclude that they should not be read out and what has been testified to in the inquiry should not be mentioned here, then obviously that's the end of the matter as far as the commission is concerned. So that's what I have in mind. So in other words, that we don't rush to do everything today. Let me get time. We can agree maybe as to when counsel for Mr. Wakeford can submit, I don't want to call it written submissions, but it is written submissions. But when I say a note, I'm just trying to indicate that it's a very narrow issue, you know. But it is written submissions on the question of whether Mr. Wakeford can read out the extracts that are said to be evidence that was given at this 417 inquiry. That's point one. Point two, whether even if he doesn't read out extracts, whether he can say what he understands to be evidence given there in his own words. And then I can take it from there. That's what I have in mind. What do you say? Is that fine with you?
Chair, I'm more than satisfied to do it on that basis.
Yeah.
But I've got no problem at all that. I think that's practical and I think that would be correct.
Yeah.
But just to sort out for record purposes, for example, he now wants to give evidence, Mr. Wakeford, about cryptocurrency and illegal. This was all done through Luna. All the evidence is there. So he's trying to utilize and select certain parts that he thinks will support his version in regards to the veracity or the credibility or the so-called dislike for Mr. Greasy.
I'm sorry, does that fall under the 417 inquiry? Because
no, it's now coming to matters relating to a different
okay, let's finish
charge.
on the 417 inquiry first.
Yeah, 417, I'm happy with
happy.
the proposal, and I think the liquidators, and I'll convey it, the liquidators are present and their attorneys,
Yeah.
and I'll convey it to the council, and I think that would be a correct approach, and we can then put forward.
Yes.
But it's just disturbing that, for whatever reason, secret documentation is in the public domain.
This affidavit, is it the one that was only given to Mr. Greasy yesterday or something?
No, he hasn't got it yet this morning.
This one, he got it this morning.
Also, so that's why there would not have been a chance to respond to it.
Yes.
Okay, all right.
But we will respond to it,
Yes.
Chair, with your permission, and we'll
Yes.
make sure it's very, very quick.
Yeah.
And, in a time turnaround to respond, so we don't delay the commission in any way. Because
Yeah.
we'd like to continue with our cooperation and assistance. But
No,
we
that's
only
fine.
got it this morning.
Yes,
from-
that's fine. Counsel for Mr. Wakeford, 417, is that fine with you?
Thank you, Mr. Chairman. Indeed, it is, although you'd pretty much dealt with it earlier, and this has been a regrettable interruption. So I'm in agreement with that. But let me say this. It's regrettable that my learned friend has interrupted my client's giving of testimony, questioning his evidence and giving evidence almost from the bar. Mr. Agrizzi can come and be cross-examined. We look forward to it. We invite it. We prevail upon you, Mr. Chairman, to find that time to deal with Mr. Agrizzi under cross-examination, and he can answer to all of these things thereafter. To now, from the bar, to criticize Mr. Wakeford must be objected to. Thank you, Mr. Chairman.
No, that's what, well, I want to say, I understand that ordinarily, if this affidavit had been given to Mr. Agrizzi or his legal team quite some time back, they might have been able to respond and put their version, in which case Mr. Wakeford would have been aware of their response, at least at the time of giving evidence, and would deal with Mr. Agrizzi's version. But since they got it today, obviously there hasn't been enough time. But obviously it's not going to help to deal with it now, because Mr. Agrizzi will respond. but it will be important, obviously, that he responds. So let's allow Mr. Wakeford to continue on the understanding that Mr. Agrizi might have a different version and that he will respond. I think what may be necessary is that during the break, maybe that issue can be discussed among the legal teams in terms of Mr. Agrizi's response, because obviously we should have it as soon as possible. Okay, and then I can approve whatever time frame can be agreed. Okay, all right. Well, we have gone beyond 12:30. It's 22:12. Let's take the tea break now. But I had intended to say, Mr. Wakeford, to stop you at 12 so that Mr. Noche could then put questions up to 1 o'clock and then we take the lunch break. Of course, part of the time I had planned to give you has been taken up by the discussion. So I think when we come back, I'll give you maybe about 15 minutes. If you can try and deal with what remains in terms of important points, then I would like to allow Mr. Noche to start putting questions to you, and then we proceed. Is that fine? Is that fine?
I hope it's fine, Chair.
Yeah, but what we can do, obviously, when Mr. Noche asks you questions, he will cover some of the things that you might not have covered. And when he asks you questions, you can then take that opportunity when you respond to deal with them. But at the end of the process, if there are issues that you feel you have not had a chance to deal with properly, just make the request to be given that chance. All right?
Thank you, Chair.
Okay, all right. We'll then take the tea adjournment. Let's resume at 12 o'clock. We are
Thank you, Chair. Tuesday, the 11th.
Yeah,
The submissions by all parties.
okay, no,
And
that's,
then,
that's
and then,
fine.
Chair, it is also pointed out to me by, I think, the liquidators that but we need your guidance on this. Mr. Watson, Gerard Watson, the one who has got the transcript, he got it through an application he made to the commissioner in the 417 proceedings. And then he was allowed by Judge Joffe. But Judge Joffe said it's only for his purpose, for Mr. Watson's purpose. The question is that I've been asked to bring to your attention that there is a ruling by Judge Joffe as a commissioner that this is only for Mr. Watson. Now, we're not certain whether Judge Joffe has an interest in the exercise of deciding whether they should now be put in public or not. But we're not certain. We seek your guidance in that regard.
Well, I think that he can be informed of what's happening here through, I think, whoever is
The
appearing
liquidators
there, whoever is
There's a
appearing
gentleman.
there, whoever is appearing there. I'm looking at, for example, counsel for Mr. Agrize, I don't know, or
Judge, the chairperson, there is the gentleman who are representing the liquidators.
yeah, well, I don't know who should inform him, but I'm saying he can be informed of what's going on here.
Yes.
You know, and if he wishes to say anything, he would be free to do so. But I don't think it's compulsory for him to say something. But if he wishes to say something,
That's fine.
that's fine. Yeah. But that arrangement that you have made is in order,
Yeah, that's
so that I have all the written submissions not later than Tuesday the 11th.
No, that's fine.
Yeah. Okay.
Sorry,
And then, chairperson?
Yeah, okay, I think before you say, if somebody wants to say something
Sorry.
about this, yeah?
Mr. Chairman, by agreement between the parties who had the discussions, there will also be submissions from Mr. Jared Watson, or should I say, African Global Holdings, because they're the ones
That's fine,
with the transcript
yes,
between him and the company. And
That's
gave it
fine.
to us. Thank you.
yeah, that's fine. Okay,
Last part. What we have done during the break, we have created a sub-bundle and which only contains the affidavit of Mr. Watson together with annexures. With your leave, it's marked BOSASA bundle 4A in brackets. And it's a small bundle.
okay,
which-
should I take it that it contains part of what I've got in this bundle, but also it has stuff that I don't have?
What it does now,
annexures.
it contains the affidavit together with annexures.
Yeah.
It contains everything that Mr. Wakeford submitted yesterday.
You didn't want to just slot the annexures at the back of this one. Is there not enough space?
That is not
Because
enough.
that's
There's not-
much more convenient.
There's not enough space. Because, Chair, if we do that, it's,
No, I think what we should do, no, because I think you should slot as many as you can slot into this affidavit and then go on to the next file if they are not enough. And then that file can then be A. You said this one is what? Or this one is 4A. That
for
can
eight,
be
that's
4B.
what we put, the main one. The main one, the big one we started with is 4.
Right.
And then we took then item 12, which contains Mr. Wakeford's affidavit, and we put it in 4A together with his annexures.
Well, this is 4A,
That
which
is,
I've got.
that is what we have put on your
Yeah.
desk during the break.
These.
Yes, it's
So
not
in
what
term-
you were working on.
Oh,
So we
are the
took,
annexures here now?
the annexures are there now.
Oh, okay, but that's what The one that I had before T was
We
for what?
took, we took the one you had before T,
Which was what?
which was item 12 in the big file.
No, in terms of bundle.
It was, we took it from bundle 4.
Yes.
What, item 12 in bundle 4, we took it and put it here in this new sub-bundle.
No, I don't like the new thing, unless it's a continuation of the old thing.
Yes.
I'll tell you what I think I would like. I would like to continue to have what I had,
Yes.
and then you can add. But if there's no space to add, then there can be another file where you then put on the other things. Then it's a continuation. You can then make the new file. You can give it a bundle number.
Fine, sure. Check,
Because I
then-
want to make sure that the references we have made are the same.
There'll be no change, it's just a change of the, but it's fine, Chair.
Yes, let's do it that way, then it's
Can we
much more
continue
simple.
now with what we have
Yeah,
before us?
yeah.
And then I will move the
Yeah.
documents.
Okay.
The-
All
the-
right,
but
then
the pages
let's
and
keep what we
everything's
have, and then we'll add if we need to add, but let's not replace. Okay. All right, Mr. Wakeford.
Chair.
Okay.
Thank you.
It's 10 past.
Chair, if I could, with your concession, Chair.
Yeah.
What I have to do,
Yeah.
from my counsel have advised me that
Yeah.
I must get through the substance of the allegations.
Of course.
And of course, my response to that.
Yes, yes.
So I'm going to finish off on the motivation,
Yeah.
which is on page.
But
This
let's
one
talk
says
about
BOSASA
the
4901.
let's talk about the time.
Yes.
What I was proposing, giving you 15 minutes to say whatever you need to say, but as I said, that's not the end, because when he questions you in relation to certain matters that you might not have dealt with or didn't deal with adequately, you can then answer fully.
Yeah.
And at the end, when you are done, if there are aspects that you feel are important and you have not had the chance to deal with them, I'll give you that chance. But your counsel will be allowed to re-examine you if he wishes to.
Okay.
You understand? So in the end, I don't think you will feel that there is something that you have not had a chance to deal with properly. It's just a way of going about it.
Just understand my heart, Chair.
No, I understand.
My heart is this, that I've waited for more
Yeah.
than 2 years.
No, I accept that.
And
Yeah.
the alleger of all of this
Yeah.
had lots of latitude.
No. I'll give you that chance. It's a question of when.
Thank you, Chair.
Yeah. But in the end, when you are done, the idea is that you should be able to feel that you have been given adequate time to deal with issues.
Thank you, Chair.
Okay, all
So to sum up, Chair, on the motivation of Agritzi. One, he primarily wanted, and I'm on page, sorry, sir, I'm on page 901, BOSASA 04901, starting at 195.
Oh, okay. Now I think I have the new file, isn't it?
I can give you the other number as well.
Judge,
Hang on.
Chairperson, what we did, we took what you have, we took it from the old file.
Yeah.
You will see, Chair, we still, look, if you see, there's a sticker which is sticking out, it says 12.
Yeah.
It was item 12 in the old file, but
Yeah.
it's sitting now on a new cover.
Yeah, but now you see, you are confusing me because remember I said let's continue with what we had. So you have taken out the certain parts.
We've taken out item 12, that is Mr. Wakeford's affidavit, and put it in this new file together with its annexures. All we've done.
What was wrong with keeping what we had?
We thought because the annexures couldn't fit in this old thick file, instead of having the affidavit on its own.
Yeah, no, we're spending too much time on this. Bring back the old file.
You have it.
We're spending too much time on it.
And then
Yes. Yeah, okay. Bring back the old file and then. Okay, so that's the old file, and there is a separate file which we will go to if necessary. Is that right? Yeah.
that is the file now with the exhibits.
Yes, so when we need to go to exhibits, we can go there.
Yes.
Okay, no, that's fine. Okay? Yes.
Thank you, Chair. I'm going to just end off on the motivation because it's
Yeah.
very important. One, he primarily wanted to
You said we
destroy.
must go to 9 something, page 9 something.
So it's page, Chair, 901.
901.
Yeah.
Okay,
Starting at point 195, the last section of it's really a summary. One, he primarily wanted to destroy the reputations of Watson and the Black Board of Directors of BOSASA, guided by his racism, to create the perception that the board of the company would have no option but to step down and appoint him as the CEO of the group or risk the business liquidating. Two, failing that, Agrizzi would want to see the group liquidate, utilizing his contacts within the media and political structures so that he may obtain the group's contracts in his own entity, that was Crioris. And three, when criminal charges were opened against him by his former employers, however, he clearly thought it would be politically expedient to utilize the commission to both repackage his own discretions while earning favor with the DA by implicating the ANC in corruption shortly before the general election, only 4 months later. So, Chair, that brings to an end the motivation, a summary of that. Chair, I've gone through the allegations and some of my responses to point out, I opened with this, but in summary, just to say that none of the facts or the so-called allegations that he presented aligned with a real-time timeline and certainly didn't match up with the accounting records both in my books and elsewhere, including African Global or BOSASA. So, Chair, the disputed allegations, I'm not going to read through, which start on page, sorry, Chair, I keep forgetting.
905.
Yeah, the disputed allegations, you're correct, Chair, 905. I'm not going to read through verbatim what was said
Yes.
in January 2019. I think we all know that he alleged that I was involved in getting someone within SARS, George Papadakis, to fix certain things within SARS. And to date, there has been absolutely no evidence to that effect. Number one. Number two, he said that I was paid 100,000 Rand a month to do that, which is patently untrue, and I demonstrate that with the accounting records and emails, strangely enough provided by him in previous affidavits, which point to the fact that I say, you haven't paid me for so many months, when are we going to resolve this? So all of that is provided in the evidence. By the same token, the Lindela contract, he states that the main reason for corrupting Anil Radhakrishna was to get an extension of the contract. Now, no extension ever took place. If you read the initial contract, the first addendum, the second addendum, there was never any such thing. So, Chair, I'm not going to, I've given you a summary of the allegations,
Yes.
both by Foster and Gritzi. And in fact, Gritzi on the cement matter refers to Foster and says, well, you tidy it up and give the whole story because I don't have it. So, if we move on, Chair, to now I'm talking to the substance of my responses. And that is on page 910, Chair, at the bottom.
Yes, I've got that.
Good. It says, the allegations made by Gritzi in paragraph 43.4 of his affidavit are false in every respect. No such meeting or discussion ever occurred. Watson and Gritzi, nor have I ever told any part with BOSASA or otherwise that Papadakis could resolve any issues at SARS. No such agreement for the provision of services in relation to SARS Invest ever existed or was entered into between me and BOSASA. No agreement between BOSASA and myself for 100,000 per month ever existed either. This is why neither such an agreement has been produced by Gritzi. As already addressed above, over the period of 2006 to April 2015, I had a consultancy retainer with BOSASA through my close corporation for an amount of 50,000 per month. This is quite evident from all financial records. My records reflect that inter alia, I received a monthly retainer of 50,000 plus VAT, and on the few occasions where payments received exceeded 50,000, they either related to expenses incurred on BOSASA's behalf or arrears payments of my monthly retainer. At no stage was I ever contractually paid 100,000 per month, whether to assist SARS investigations or for any other purpose. The only months when I received 100,000 was as a result of arrears payments or catch-up payments of my monthly retainer from months when Gritzi had not paid me. The schedule of invoices sent and payments received from BOSASA companies, and that's annexed in EA 218, but Chair, I'm not going to take you there in the interests of time. I'm sure your team are very able to scrutinize that as to its authenticity and correctness. Reflects that Gritzi first stopped paying my monthly invoice in December 2009. Subsequently, when payments to me resumed on the 24th of June 2010, double payments were processed to me as catch-up payments. All amounts received by my CC have been confirmed by the Commission to my bank statements. I further appointed independent auditing firm Full Serve Chartered Accountants to analyze my financial records for the purposes of this commission. Full Serve reviewed my CC bank account statements going back to 2009 and April 2015, when my services with BOSASA concluded. BOSASA's general ledger of payments to my CC from 2007 until April 2015, and my invoices and ledger of receipts of payments during that period. The letter confirms inter alia that the escalated payments that I received were previously unpaid months together with the current month, hence a double payment for that month, and this is normal business practice. That these payments were nothing more than catch-up payments for previously unpaid invoices is clearly reflected in email correspondence between me and Agritzi over the period. Agritzi provided these emails to the Commission previously in an attempt to support his representations. However, contrarily, they actually prove the truth of my own representations to the Commission. In the email correspondence of 21st August 2010, I said the following to Agritzi. Hi, Angelo. Any conclusion on my July 2010 catch-up payment? Is there any matters I'm unaware of? If there are any, please let me know. No offense. The reason this was sent was as Agritzi had paid me my first catch-up payment in June 2010, but then once again did not pay me an amount for July 2010. And Chair, I go on and on quoting different emails proving that what he said was an absolute lie. But, Chair, I'm going to speak to the fact that based on some of the info we have, that Agritzi purposely held back payments due to me, speaks to the relationship and why he's gunned for me here. It was specifically Agritzi's protests that prevented me from being paid on time. Payments due to me have had to be doubled up when they weren't paid, with records of this evidence stating, and there's an annexure to that effect. I'm not going to read from the 417 transcripts once again, Chair, and I'm not going to speak to, let me just tell you what page it is. We are moving quite quickly, Chair.
No, that's fine.
We're on page 916.
Yeah.
I'm going to speak to the so-called link, because he said I was paid to assist with SARS. So at the bottom of that page, I said, I'm reliably informed that the depths of Agritzi's lies can be seen from other documentation, which I can't speak to now, but I'm sure you will make a ruling on that, Chair, because he's definitely perjured himself on a number of different occasions. I'm not going to speak to Foster's stuff, because it's really a repeat of
You dealt with
what
that,
he
Edward.
said.
Mhm.
Chair, I need to touch on Lindela and the DHA, which was the other major issue. That is on page 927, Chair.
I've got it.
Thank you, Chair. In paragraph 44.4 of his founding affidavit to the Commission, Agritzi attempted to incriminate myself and Anil Radhakrishnan in matters of state capture by stating that we both had been party to facilitating a 5-year extension to the contract between BOSASA and DHA for the operation of the Lindela Repatriation Center. And 2, more favorable contract terms were included in the contract for BOSASA. Again, I'm not going to refer to that.
Yes.
And I'm not going to refer to that. The review, the following page, under point 272, Chair, the review that Agritzi refers to in paragraph 44.2 in his evidence relates to 2 addendums to the original Lindela contract of 2005. These addendums, the second and third addendum to the 2005 contract, were concluded and signed on 2 different dates, one being the 18th of February 2008 and the 13th of March 2009, respectively. The original Lindela contract was for the provision of detention services for illegal foreigners at the Lindela Repatriation facility inclusive of accommodation, meals, and security. This contract was concluded between Leading Prospect Trading, a subsidiary of the BOSASA Group, and the DHA, and was for a 10-year period, Chair, of 1 October 2005 to 1 October 2015. So there would have been no need in 2009 to concern oneself with an extension. In 2007, the Home Affairs Turnaround Project was implemented, involving large-scale restructuring of the Department of Home Affairs. Fevertree Consulting, commonly known as Fevertree, was contracted by the DHA to determine the scope of the turnaround project and identified a comprehensive set of transformation projects for the department, including reviewing and renegotiating existing contracts. And Chair, this was a very small part of the overall turnaround. Minute, in fact, if one had to look at the scope and scale of that project. And Chair, this project won international awards. We were even invited, Sven de Kock of Fevertree was invited to Princeton to deliver a paper on this public sector project. And it was granted other awards locally as well. It was, in my view, a shining example of how you go about transforming a state entity. In early 2007, I was contacted by the Minister of Home Affairs, who at the time was Nosiviwe Mapisa Nakula, who requested me to oversee the then envisaged turnaround project. This project was endorsed by Cabinet under the presidency of the former President Thabo Mbeki. This project was endorsed by Cabinet, given the ongoing crisis within Home Affairs. Due to a lack of senior leadership, numerous suspensions within the DHA, a legacy of poor infrastructure and IT systems, as well as poor governance, a poor governance environment, Fevertree, the local partner of A.T. Kearney, was appointed. A.T. Kearney were highly regarded due to their previous success within the public sector in South Africa, namely at the South African Revenue Service, SARS, and internationally through successful execution of Home Affairs-related projects in the USA, Belgium, and Netherlands. I informed the Minister at the time that I was providing consultant services to the Premier of the Eastern Cape Province, as well as advising the BOSASA group of companies. My appointment as Ministerial Turnaround Advisor was through my close corporation. This lasted for 2 years, 2007 to 2009, and ended the month before the 2009 general elections. As stated above, I continued to consult to BOSASA and other clients in the private sector. And one can even scrutinize the hours I put in there. It wasn't a full day, because I had other clients. During the turnaround project, new and improved service level agreements, commonly known as SLAs, were negotiated with all key suppliers to the Department of Home Affairs, including CETA, which was a government entity, Telkom, a government entity, SAPO, a government entity, XPS, a government entity owned by SAPO, Ntweze Double Ring, GPW, or Government Printing Works, and Leading Prospects Trading. Of these suppliers, only Ntweze Double Ring and Lindela had existing contracts in place. All other contracts had expired or did not exist with DHA. At all material times when in relation to BOSASA or any of my clients, I was mindful of possible conflicts of interest and without exception made full disclosures and recused myself from any decisions involving or relating to my clients. I was the Minister's turnaround advisor and program manager and indeed at the helm of the turnaround project. However, I oversaw 55 projects and 7 work streams and was monitoring performance of these against contracted deliverables. I was at no stage whatsoever even remotely involved in the Lindela contract renegotiation. I never attended or took part in any meeting with Agritzi or Watson concerning the renegotiation of Lindela. I'm going to skip a bit of that, Chair, and move on to 283. I've never been party to any deal with Radhik Krishna and or Agritzi and or Gavin Watson. Agritzi would have met Radhik Krishna at the respective negotiation sessions between the DHA and BOSASA. Once again, Agritzi was at the helm. If you look at all these contracts and the addendums, he was the signatory to all of them, not Gavin Watson. The culmination of these negotiations was the second and third addendums to the original 2005 contract as referred to above. As already stated, I was not a part of these negotiations in any way. However, I have taken the time to review the contract and the two addendums concluded while I was an advisor to the Minister of Home Affairs on the overall turnaround project. Chair, the salient points of the second addendum, that was in 2008, are: one, the DHA would receive a monthly saving of 640,000. Two, the minimum monthly threshold of 3,250 persons with the DHA was liable for within the original 2005 contract was reduced to 2,500 persons. Variable costs for food would only be applicable when the number of immigrants held at the facility exceeded the minimum threshold of 2,500 persons. Annual adjustments to pricing would be based on the prevailing CPIX, that's your inflationary formula. This condition, however, was already present in the original contract. The salient points of the third addendum, and this is even better for the fiscus. One, the parties undertook to meet by April 2015, before the expiry of the original contract in October 2015, to discuss the extension of the contract beyond the initial period of 2005 to 2015. The DHA may at this time, in its sole discretion, extend the initial period until the 31st of October 2018. If extended by the DHA, the contract would continue on the same terms and conditions as the current agreement. However, the monthly charge payable by the DHA would be reduced by the capital cost of the facility of 1.8 million per month. A reduction of the monthly amortization cost of the facility payable by the DHA of 420,000. If the occupancy of the facility was below 50% of the minimum threshold of any 36-month period, the DHA would be able to reduce the variable cost component of the monthly charge. The DHA were given a CPIX holiday of 6 months, which ended up, by the way, Chair, becoming 5 years, because Mr. Agritzi failed to implement within his own jurisdiction and his own company, where he was Chief Operating Officer and de facto CEO, he failed to remember this clause, and in fact, benefited the state even more. BOSASA would provide additional medical services at no additional cost, and BOSASA would spend an additional 5 million in upgrading facilities and would provide the DHA with remote access facilities. The DHA would have an option during the full length of the contract to purchase the Lindela facility at a price determined by a registered independent valuer. The DHA would have a right of first refusal on any other to purchase the facility by a third party. Each and every individual contractual term of the two addendums above was for the benefit of the DHA and not the benefit of BOSASA. I pause here to draw attention to the fact that the extension referred to in the contract was only to be determined by the DHA 6 years after the signing of the third addendum. A decision to be made 6 years after myself and Radhakrishna were no longer connected to the DHA in any way. No extension was eventually awarded to BOSASA in 2015 anyway. In fact, Agritzi has attempted to repurpose the demands he himself made on the DHA, where Agritzi had stated to the DHA at the time in 2007 that he would only consider reducing the monthly invoice to the DHA under the condition that the original contract be extended for 5 years. This is addressed in page 9 of the Lindela negotiations under Outcomes Deep Dive, which is EA 295. But Chair, I'm not going to take you there in the interests of time. At this time, the recommendation was that the DHA should only consider a 3-year potential renewal. Ultimately, though Agritzi was never afforded the extension he demanded. Regarding cost savings, implemented the report of the accounting officer in the 2000-2008 annual financial statements, and you'll remember, Chair, that he was the Director General, Mavuso Msimang, a man of great caliber, and who ran that department extremely well. And he knew that he was in charge. Not me, not any DDG, he was in charge. And he did his work properly. This was based on the annualized savings of 7.68 million as a result of the 640,000 monthly saving provided. This would create future cost savings of 68 million on the remainder of the Lindela contract. In addition to the cost of the contract decreasing immediately, if the contract was extended at the sole discretion of the department, the cost would be further reduced by an annual 1.8 million per month, producing additional savings, future savings of 112 million. The Commission's investigators have subsequently reviewed actual billings by BOSASA to the DHA and confirmed the following. Before the renegotiations commenced, BOSASA invoiced the DHA 3,250 persons multiplied by 30.4 days, because that's the average month in a year, multiplied by 79.90 Rand per person, which came out at 7.8 million monthly. After renegotiation, the two addendums concluded in February 2009. BOSASA invoiced the DHA 2,500 persons times 30.4 times 99.41 per person, which came out at 7.5 million monthly. One would ask, why the increase to 99.41? That's factoring in principally inflationary increases, which would have happened anyway, Chair. This amount remained the same for the following 62 months until March 2014. This means that no annual CPIX increases were implemented over this 5-year period. This confirms that the price paid by the DHA over the two addendums was 333,000 less than the DHA paid before negotiation. Clearly a benefit to the DHA and not BOSASA. However, this ignores the fact that the increase in price from 79 to 99 per day was brought about as a result of the CPIX, which I've just mentioned. If this is considered the true price before renegotiation for comparative purposes is 3,250 persons times 30.4 times 99, which equals 9.8 million monthly. Therefore, in reality, the price after renegotiations represents an immediate decrease in billing of 2.2 million monthly, or 27 million annually. And Chair, you'll remember when he spoke about this in January 2019, he was going on about how famous this was the money-making contract of BOSASA. It constituted a small part of their total turnover, number one, and number two, clearly wasn't, after the renegotiation, the real money-making beast that he spoke about. And Chair, this is merely perusing the facts and the legal documents involved. This exercise was performed for the period 2009 to 2015 when the contract expired, and demonstrates the true financial saving by the Department of Home Affairs over this period amounted to 325 million, Chair. A lot of money. And a table to prove that, Chair, is on page
937. Is that the one?
Yeah, I think you're right. That's right, Chair.
Yeah.
937. I'm not going to go through it now, but
Yeah.
it really differentiates between what the contract was in 2005, what it became after the 2009 second addendum. And it proves beyond any reasonable doubt that there were massive savings for the state and for the fiscus, and hence the awards given to this project, Chair.
Well, you said it proves what the contract was in 2005, but I see the table seems to start in 2009.
Chair, we start in 2009 because that's when the second addendum was completed.
Oh, okay.
So you get the full benefit, and
Yes.
we demonstrate that over a period of 6 years.
Okay.
So it was basically halfway through the contract, taking it to the end of the contract. And they could have continued with the savings, and I don't know why, but they didn't then extend at their own discretion. They negotiated a new contract. Now, I don't know what happened with that one.
Okay.
Thank you, Chair. Chair, just to get on to Radhakrishna, I'm aware that Radhakrishna himself completely denies Agrizi's accusation of an agreement with BOSASA for the payment of 7 million regarding the Lindela renegotiation. However, on plain logic, it appears unlikely that a consultant would be rewarded with 7 million having cost them, or his so-called corruptors, 325 million, because that's what they didn't earn as a result of the saving. I've further provided extracts of the income statement and the annual financial statements of Leading Prospect Trading, which demonstrates that before the renegotiation of the contract in 2007, Leading Prospect Trading earned an annual profit of 22.6 million. After the renegotiation, this profit consistently decreased year on year until 2012 and 2013, when the company actually made losses. These financial statements are indicative of the profitability of the Lindela contract, as Leading Prospect Trading was a single-purpose entity exclusively for the operation of the Lindela contract. Agrizi's representations in paragraph 44.4 of his affidavit to the Commission are false in their entirety. One, he says the Lindela contract was not extended for, sorry, Chair, I'm not quite sure if this is taken from the 417. Is this taken from the 417? Not, thank you. I'll carry on, Chair. The Lindela contract was not extended for 5 years or at all. The contract had already been in place for 2 years prior to this review, and thus this did not require National Treasury approval as alleged by Agrizi. The DHA has already confirmed this to the Commission. 3, no more favorable contract terms were included in the contract. In fact, Agrizi himself no longer appears to hold this claim. And I won't say why, Chair. The effect of the negotiations and review was to bring the cost per capita to the department down to only 35% of the cost per capita of similar services provided at private prisons, and there are some in South Africa, and the Department of Social Services as addressed in the Lindela negotiations, and it's all attached in the evidence, Chair. As regards paragraph 44.6 of his affidavit, or Gritsi's affidavit, which once more refers to the extended contract. This statement can only be false. As confirmed above, the contract was not extended. Furthermore, I had at no time had any discussions with the Gritsi about the benefits of an extended Lindela contract. I cannot speak on behalf of Scopa or opposition political parties. However, it is only logical to assume that anyone would look favorably upon the DHA paying less and receiving more, as the terms of the addendums dictate. And Chair, of course, Lindela as a concept or as a state policy has its opponents. There are some people who don't believe that you should repatriate and that you should detain. But in most democracies worldwide, there is some form of detention and repatriation, unless you are declared a refugee. And as much as people jump up and down, it's a reality, it's there. And we had to deal with that policy reality. It isn't for state departments to question government policy. They just have to implement it. It is important to note that Fever Tree consultants operated at Home Affairs in a supportive capacity. They performed research and analysis followed by specific recommendations. As a support consultant working with DHA officials, Radhakrishna was only one member of a team responsible for negotiating these savings. All statutory powers, however, remained vested in the accounting authority, being the Director General and his subordinates in terms of the respective delegations of authority for the necessary approvals, including procurement and contracting. Significant outcomes from the turnaround included reduced turnaround times for identity documents and for passports, and a customer-centered chair that answered 95% of calls in 20 seconds and resolved 90% of calls on first contact. I don't know what the situation is now, and we always spoke about making the transformation stick, but I'm sure that if you speak to Home Affairs, they'll give you an idea of what's taking place now. Gritsi has attempted to manipulate reality in suggesting that any surreptitious payments were made to Radhakrishna by BOSASA. Subsequent to the conclusion of the Lindela negotiations, by the way, Chair, I do have copies of Papadakis and Radhakrishna's affidavits. We got Papadakis's yesterday, and Radhakrishna, we received permission from the work stream to get it directly from him. Radhakrishna is a public sector finance expert, and I would imagine it was for this reason that Gritsi approached him in regard to send a proposal on the 8th of October 2009 detailing the works to be formed, and that was for a fleet management contract in the Eastern Cape through one of their subsidiaries, Querano Pakisa. Chair, I'm almost finished. My sole involvement in this process was that Gritsi asked me for input on the draft proposals of Achille.
Okay. Phakathi wayo siyathokoza kuba
manner by Radhakrishna invoicing BOSASA in the name of Distinctive Choice Wines at some later stage. The Commission, however, has confirmed that this only occurred in July 2011, 2 years after Achille and Radhakrishna's company had already invoiced BOSASA directly in November 2009. It is counterintuitive to suggest that a relationship would be revealed in plain sight only to be hidden 2 years later?
I'm quickly looking at your brief submissions. It looked like they would just be a repetition of what you have already said so far, at least at page 942. Is that not so?
Sorry, Chair, do you want me to continue?
No, I'm saying that I'm briefly looking at your brief submissions.
Yes.
At the end, and it looks like they would just be a repetition of what you have said. But
Correct.
I've only looked at 942. And if they were going to be just a repetition, maybe you shouldn't deal with them, but you can round off.
Chair, I'm happy to,
Yes,
to end
yeah,
off.
to round off.
And just to say,
Yeah.
just based on the evidence in relation to SARS, there was no investigation. Chair, if you ask me, because I saw Papadakis' statement yesterday for the first time, my sole role in assisting Papadakis in 2008, 2009 was because he was building a house. It was prior to the World Cup. There was a shortage of cement, and if you're building a house and not a factory or a shopping center, you get pushed to the back of the queue. And as I understand it, he had meetings with the Watsons, and he contacted me. I thought that they had shares in AfriSam, so they could get it much cheaper. Clearly, they didn't do that. But I merely referred the builder or the construction manager, whatever he's called. He contacted me. He obviously got my number from Papadakis. I referred that through to Agritzi. He could have referred that to Foster. From time to time, I was phoned to say, I can't get hold of these guys. Can you follow up for me? And I did. There was nothing malicious. There was no quid pro quo. As far as I understand, he paid for the cement. It was done above board, just helping a friend who, in fact, was one of the key investigators at the Rand Commission. So I've known this man for many years, and I have the highest respect for him as a man of integrity and honor, and as a man who has, he was at the Rand Commission, he was at the Palais Commission, he's been to a variety of commissions and done sterling work for this nation and for this country. And I would never put him into such a compromising position. In fact, while he was at SARS, he didn't meet the BOSASA people, as far as I know. And yes, I did from time to time visit him, unrelated, and I never asked him to influence a matter within SARS. And I didn't even ask him for advice, because we had some of the best advisors in the country. We had Advocate Solomon's SC. We had, I mentioned them in my affidavit, some top-ranking people. So the substance was always presented. It was always presented. The issue for me was to keep a watching brief on threats. What threats? Were there perhaps forces within SARS? Were there forces within the criminal justice system? Were there forces within the media? Were there competitors trying to undermine us? That was part of my brief. And I make no bones about that. I would say to him, George, if he had time to see me, of course, I'd often ask for a meeting, I never got it. But I would say, George, from a process viewpoint, administrative justice type stuff, how should we handle this? And he's, for instance, I think he got tired of me because I kept, aren't we under attack here? Because I didn't know a lot of the things that Agritzi and his fifth column were doing behind the scenes. I had no clue. So when we were being attacked like that, I felt it incumbent on myself to engage with the different players in the market, do some good business intelligence, find out what's going on, and to, in fact, act on that info. The letter, and Advocate Noche will show you quite a bit of emails and evidence, mostly outside of Papadakis' tenure at SARS. He'll show you stuff. But even during his tenure, there could be one or two, I don't think so. But even during his tenure, it was administrative. You know, you've got the right to object, you've got the right to appeal. Those are the things that I was interested in. But more importantly, why are we being attacked all the time? And I even assisted with a letter which went to the commissioner of SARS. Firstly to the acting commissioner and then to the commissioner himself. And apparently there was a very good meeting that resulted from that. So, I've got nothing to hide. I really don't. But the fallacious type content that's been alleged against me had to be answered. And that's why I want to thank you personally for making it possible for me to at least have my say today. Thank you, sir.
Thank you, Mr. Wakeford. I ended up giving you more than the 15 minutes, but I think it's okay. You have, I think you have had the opportunity to put your side of the story. We are going to adjourn for lunch now. But before we do that, counsel for Mr. Wakeford, I guess you will only have an idea of how much time, if any, you might need to re-examine after Mr. Noshe has finished his questioning, I guess.
Mr. Chairman, I gather you're asking that question on account of your latter session.
Yes. But in the end, I do want to make sure that everybody has had a fair opportunity.
At this juncture, I don't think it's going to be very long.
Yes, yeah.
But
then see what comes
it might
out
have been
of it.
15, 20 minutes at this juncture.
Yeah.
Let's see. So
Yes.
I can give you that indication. I trust the assist. Thank you.
That's fine. I wanted to say that my experience in this commission has been over the years that the experienced practitioners tend to take shorter on re-examination. So when you say 15 minutes or 20 minutes, that accords with what I would expect.
Thank you,
Yeah.
Mr. Chairman.
We are going to take the lunch adjournment now. Unfortunately, I've got to attend to something that relates to the commission, with the result that we won't resume at 2 as we normally would. We'll resume at 2:30 so that I can attend to something urgent that I need to attend to relating to the commission. And then we will resume at 2:30 then, and then continue and see how everything goes.
Thank you, Chair.
As you please, Mr.
Okay, all right. We adjourn.